Good afternoon, everyone. As Chantel mentioned, my name is BJ Jones. I direct the Tribal Judicial Institute at the University of North Dakota Law School. We're a training and technical assistance provider for the Bureau of Justice Assistance and other federal agencies. I'm primarily, though, going to be drawing upon my experiences as a legal services attorney that did a lot of defense of persons subject to civil commitments, as well as my experiences as a judge in Minnesota. I've worked as a judge for various tribes in Minnesota and the Dakotas, both 280 tribes as well as non-280 tribes. And I'm going to talk about the use of a civil commitment process through the tribal courts to help tribal members who are misusing substances to the point they constitute a danger to themselves or others. Also, people who suffer from mental illness, whereby they may be a danger to themselves or others. And then the third category of civil committees that I see tribes sometimes committing through their processes is pregnant women who are abusing substances, and that's a more controversial one to commit persons civilly using that process. But before I actually talk about it, and then I'm going to turn it over to my colleague, Michelle Park. She's going to talk about competency or determining doing civil commitments in the context of determining incompetency in criminal proceedings. But before I start talking about the actual process, I think it's extremely important. If you're from a tribe that already has a civil commitment process in place, uh, or if you're from a tribe that doesn't, I think three main issues you really have to look at before you delve into this type of jurisdiction. But one of the things that really concerns me is you've got to understand a lot of tribes, because we don't have a lot of secure detoxification facilities and other appropriate mental health facilities. You've got to realize when you embark upon exercising this jurisdiction, you're going to be utilizing oftentimes your tribal jail or county jails to detain people on civil orders. And there are a lot of tribal leaders that have a problem with this. I've seen situations where persons have been subject to commitment, don't comply, don't follow through, and then wind up being incarcerated in a tribal jail. And it's purely for a civil matter. So some tribes have a problem or a concern with that. And I think it's important that in your community, you address that. Do you have sufficient infrastructure to really assist people who are misusing substances, who have mental health issues? The second issue you really have to look at is what type of treatment modality is appropriate in your community. What does your community think about treatment, and what are the viable options? I know in Minnesota, a lot of the tribes use medication-based treatment, things like Suboxone and methadone. And I've seen that actually been fairly successful for some tribal members who have been on that. I know people who have been subjected to proceedings many years ago still receive regular dosing of these medications, and they seem to be able to function, raise their families, also have employment. But other tribes in the Dakotas that I work for kind of don't see that as an appropriate way to respond to an unhealthy lifestyle of addiction or mental illness. Uh, I've heard some people have equated it to taking someone who's addicted to vodka and getting them to start drinking gin. I mean, so that maybe not be appropriate type of treatment in your community. But I think one of the things you have to look at is, do you have an inpatient treatment facility available in your community, or do you have access to facilities off the reservation? But when you look at off the reservation, you have to realize that uh, treatment is not a medical science. I mean, I think there's been a series of articles, for example, about various treatment facilities in Arizona who were exploiting Native Americans and Native tribes and the state Medicaid fund down there to get people into treatment. And it turned out these treatment facilities were nothing more than flop houses. People were getting drugs there more than they could get off the street. So it's extremely important to assess what you have as far as infrastructure in your community to provide treatment. Then the third thing you have to look at globally in your community is, how is this going to be paid for? I'm going to talk a little bit about a lawsuit against the Indian Health Service that resulted in a determination by a federal court in the Eighth Circuit that the Indian Health Service has a trust responsibility to provide for the mental health and substance misuse in tribal communities. But you may, there's also a case I think out of the Ninth Circuit called McNabb versus Boeing that holds the same thing. But remember, the Indian Health Service is always a payer of last resort. So you may have to be looking to medical assistance to pay for treatment or mental health care, or some tribes have their own form of insurance to do that, but you could expend millions of dollars doing that. So when you start embarking upon exercising this type of jurisdiction, I think it's extremely important that you look at those three issues within your community and make sure that you have appropriate infrastructure available. Okay, so what I'm going to talk about is the use of a civil process to commit a person. That's force a person to obtain some type of treatment or mental health care. And generally, the standard is the person has to constitute a danger to himself or others. So I'm going to talk about when it's appropriate, who has standing to bring these types of determinations, what role the Indian Civil Rights Act plays in determining what rights a committee has, and also the right of counsel in these cases. I think I can control the slides. If not, maybe we can go to the next slide, Catherine. Okay. And again, we got to look at the statistics, and it is true that statistically speaking, Native Americans do suffer more from substance misuse and mental health concerns. There's also a huge problem with overdose deaths in tribal communities. And it disturbs me sometimes when we point to these statistics, which, you know, paint a bleak picture of tribal communities. And I always try to balance it out with a stat I read from SAMHSA many years ago. SAMHSA came out with a report that said the one racial group least likely to use substances are Native people. So yeah, there's a problem, I think, with substance misuse in tribal communities, as well as a prevalence of mental health issues. But always remember, there's always this core constituency in Indian country that totally believes that drinking of alcohol, using any kind of substances, is contrary to the culture and traditions of that tribe. So you always have to tap into that core constituency of the community to make sure they're being heard with regard to how you can help those members who are misusing substances. And here's some stats that I think we got from the Indian Health Service about what the issues are out there in tribal communities that we're trying to address through the civil commitment process. It's not only suicides, but overdoses. I'm at a tribe today where several weeks ago we had a young man arrested for ingestion of methamphetamine. He became unconscious in the jail, and we had to transport him to the hospital, and unfortunately he wound up dead. And I know a lot of the street drugs that are being used now in tribal communities, a lot of them are laced with fentanyl. So even smoking marijuana that you purchase on the street could constitute a danger to yourself, because of the prevalence of fentanyl in these street drugs. Okay, the next slide. So you need a holistic approach to how to help tribal members who are suffering from these, and a civil commitment process, civil commitment law in your tribal court is an important way to deal with this. And it's irregardless of public law 280 or not. I mean, in fact, if you don't exercise criminal jurisdiction, this is a great opportunity for you to exercise civil jurisdiction to help your tribal members who are suffering from substance misuse or mental illness. And in fact, I think, personally, I believe that Public Law 280 did not give the state jurisdiction over these kinds of civil proceedings because they're not purely private civil actions. So I think your tribe still has original exclusive jurisdiction, even in a 280 state, to commit a person for mental health or substance misuse. So it's a combination of all these. You have to have the appropriate infrastructure in order to do evaluations and treatment and counseling service for your tribal members. Then you have to have that law in place to have that legal infrastructure. And we're going to talk a little bit about some of the laws that are out there now for tribal communities. So what is a civil commitment? Generally, a civil commitment is the use of a civil procedure in your tribal court to compel a person to obtain treatment or services necessary to counteract their substance misuse or to help them with their mental health issues. It is a coercive way to force people to do things. And again, as I indicated, it also involves oftentimes the use of a tribal jail or a county jail to house someone who is a danger to himself or others. And that's gets controversial when you start putting people into a jail when they've not committed a crime. And there's a lot of pushback against the use of civil commitment proceedings in this way. And I know a lot of states have really, it's almost impossible in some states to civilly commit people. Tribal communities have been more open, more receptive to the use of the civil commitment process. I think a lot of times it goes hand in hand with a wellness court. I was a tribal judge for a tribe in Northeast South Dakota, and we had a wellness court. We called it a treatment court. And we also did a lot of civil commitments, but we were able to meld those two together. So when we would have civil committees who, after completing treatment, would oftentimes get into our wellness court. So what are civil commitments? Civil commitment is the use of a civil process to order a person to get help, to get substance misuse assistance, or to get mental health care. Now, most of these, the typical standard for this is you have to prove by clear and convincing evidence that the person against whom this petition's been filed either is suffering from substance misuse or a mental health issue, and the person constitutes a danger to himself or others. And generally, the burden of proof there is clear and convincing. I know tribes, though, that have lowered the burden to preponderance of the evidence, and there's a debate about whether that comports with the Indian Civil Rights Act, because remember, this is a deprivation of liberty. A person is being compelled against their wish to get services, oftentimes secure services. So I happen to think clear and convincing evidence is probably what is required under the Indian Civil Rights Act in order to commit a person. But you have to, if you're going to exercise this kind of jurisdiction, you have to make sure you have professionals who can do evaluations to get people into treatment or mental health services. And if you're going to rely upon off-reservation treatment providers, sometimes you've got to make sure the person doing that evaluation is certified to do that, or other treatment programs will not accept those individuals. Next slide, please. Oops, sorry. Yeah, and here's the standard that's generally used by tribes to make a determination of whether this person is subject to uh, civil commitment. Danger to the person, to danger to himself or others is the general standard. But as I mentioned, because of the prevalence of fentanyl now in a lot of street drugs, even THC, marijuana, I think the use of any street drug now potentially could be injurious to someone's health or welfare. It could result in death. I've seen fentanyl overdoses from young people who just were smoking marijuana that they purchased. It was laced with fentanyl. So that's generally the standard. Now, some tribes use a different standard, but I think this is the standard that the Indian Civil Rights Act would probably require, some proof that without committing this person, they may harm themselves or others. And again, then the issue with pregnant women, I'm not going to talk too much about that. Generally, the standard there is that you're designing a process to protect the fetus, the unborn child. And some tribes have that in their system. I know I was the chief judge for a tribe that would allow the court to commit a pregnant woman who was using up until the point of when the child was born. Now, that gets very controversial, though, when you're having to house someone like that in a tribal jail, if you don't have other services or facilities. So now, there's another issue about who has standing to bring these kinds of proceedings. There seems to be three uh, methods by which these cases are brought. The one method I like is family members can file a request with the court, then the tribal prosecutor or presenting officer looks at the request and then files on behalf of the tribe or a tribal program like behavioral health or mental health program. Uh, I think that's preferable to what some tribes allow any interested person to file a commitment petition. The problem I've seen in jurisdictions that allow any interested person to file is family members don't know how to move these cases along. They don't know how to prove up evidence in a court of law in order to get a family member committed. I've seen other tribes that have it in their code that any interested person can file this. What's an interested person? One jurisdiction I'm familiar with, the ex-spouses would file these things, and that's probably beyond the pale to allow that kind of person to file. Most tribes allow family members to file, but I think the best system is when the tribe itself is the petitioning party, then the tribal resources can be called to bear to help the individual. In most tribes don't typically require or appoint counsel in these unless the person is so mentally ill that they don't have any idea what the proceedings are about. Oops, sorry. Oh, so here's the process in tribal court. First of all, generally there's a petition filed and there's a request for an emergency apprehend and hold order if the person constitutes a danger. And again, many tribes, when these app and hold orders are issued, house the person in the tribal jail until there can be an initial hearing, usually between 48 to 72 hours, at which time the person's apprised of his or her rights, and the court can assess whether the person is a danger and needs to be held until there's an evaluation. Then there's an evaluation by a mental health professional or a substance abuse professional to determine the level of care that person may need. And then there's generally what's called an admit-deny hearing after the evaluation, where the person can acknowledge that they need civil commitment or they can contest it. And if they contest it, then there has to be an adjudicatory hearing where the person is proven by clear and convincing evidence to be subject to an involuntary civil commitment. Some tribes have their public defenders represent tribal members in these kinds of proceedings. Other tribes don't have the resources for that. The person can get their own attorney, but there's no mandate of appointment. And then after the person has been assessed, if the person goes to treatment, there are regular review hearings to determine if the person remains in compliance. A lot of tribes put a limit on the amount of time the case can remain open. I'm familiar with tribes in Minnesota that have a year. The case can stay open for a year. Other tribes have limited to 6 months. So because if these cases have an open end, they never end, then this person can constantly be called back into court, be picked up on these orders if they violate their aftercare or treatment programs or plans. I mentioned when I was a legal services attorney, we actually started this litigation called White versus Califano against the Indian Health Service because they were not providing mental health or substance misuse treatment for tribal members. And the federal court ruled that there is a trust responsibility for the United States through the Indian Health Service to provide these services. And the interesting thing after this case was decided, the Indian Health Service actually contracted with our legal services program, and we traveled to the state hospital and other facilities where people had been placed in treatment. And I got to tell you, I was absolutely shocked when I traveled to the state hospital in Yankton, South Dakota to conduct hearings. I represented clients who had been there for up to 10 years and had not had a review hearing in years. I remember one gentleman, an elderly gentleman from the Rosebud, he had been in that hospital for 10 years. He had been committed by a tribal court proceeding. Indian Health Service was paying, but there were no regular review hearings. And I got to tell you, the only thing I could determine that he suffered from, he couldn't speak English, because I got his family to come over there and we were able to have a hearing and he was eventually released. But if the Indian Health Service is involved in funding, this White v. Califano said the federal due process rights are applicable, and that includes the right to an attorney in these kinds of cases. And here's some examples of what tribes have done in their civil commitment process. Here's Turtle Mountain talks about the right to counsel, the right to notice of proceedings, closed hearings. Most tribes make these confidential closed hearings. Prairie Island Indian Community, there's their code. I'm the chief judge at Prairie Island. We do civil commitment proceedings. The tribe, through their insurance, will pay for some of these placements. But I got to tell you, like I said, treatment isn't exactly a medical science. I've visited a lot of treatment facilities that have excellent facilities, spa, they have, you know, gourmet dining and everything. But, you know, the success rate for people who go through treatment there is not that great, and people tend to relapse. So you've got to have a relapse program in place to help folks. And here's some other examples. I'm coming up against my time. But I give you these examples not because I say this is the law, this is what the best process is. You got to explore within your community how you want to operate these kinds of programs and systems. And then here's the other thing. A lot of times these civil commitment orders through tribal courts, in order to get services to your tribal members, you need to domesticate them or file them with a state court. Because some states will not accept tribal members who are committed pursuant to a tribal court order unless there's a cover order from the state. Now, one thing you have to watch about this, we found this out in Minnesota, is in some states, if you're found to be in need of civil commitment, there are a lot of civil forfeiture things, like you can't get a firearm, for example. So if you may watch that, you may want to talk to the state and say, hey, the ones we file, we don't have that firearms disqualification under tribal law, because that could impact a tribal member's treaty rights. If you file a civil commitment order in a state court in order to get services through the state, I personally don't understand why these facilities require you to get a state court order to honor the tribal court order, because these folks, these tribal members, they're citizens of the state too. But be aware that that could be a little tweak that you got to watch. All right, I'm going to turn it over to my colleague, Michelle Parks, so we can hear her talk about competency and commitment in that context.
Thank you, BJ. Hi, everyone. And just by way of introduction, my name is Michelle Rivard Parks. I'm the Associate Director at the Tribal Judicial Institute, as BJ had mentioned earlier. Also, for my part, I'll be coming and discussing the competency proceedings. And in terms of competency, with my background, I also serve as the Chief Justice of the MHA Nation Supreme Court. I have a background as a tribal prosecutor and a tribal attorney. So I've done some of the code development work, but I've also adjudicated criminal cases in tribal courts. And so we wanted to take some time to not only address civil commitments, but we wanted to talk a little bit about competency in criminal proceedings. And so we have civil commitments, which, as BJ has mentioned, are these civil causes of actions, the purpose of which really is to compel an individual to receive mental health services or to receive substance misuse services when they may not want to do so. And so it's really the court compelling them to do that. Whereas when we're talking about competency, we're talking about competency in the criminal context, where we have an individual who is being adjudicated for an alleged crime, and questions arise during that process as to whether or not they are competent to stand trial for that. So that's really the big difference between the two. And Catherine, I'm not seeing where I can advance, so if you could just next slide, please. Thank you. And so when we talk about competency hearings, we really have one of the factors that must be present is we have to have an individual who has been charged with a crime, but their mental health typically is what's going to bring about a question as to their competency to stand trial. Whereas if you recall on the civil commitment side, we've got substance misuse and or mental health, which might give rise to a civil commitment proceeding. In a competency hearing, we are focusing on mental health issues. And these competency questions can be raised at any time during the adjudication of a crime, whenever it is determined or discovered that an individual may have competency issues. And one thing where this can get a little bit confusing for some is that the actual competency hearings are often adjudicated in a civil court, but they impact the criminal adjudication. And so that competency to stand trial, once it's raised as an issue, we may go over into the civil court to adjudicate whether or not the individual is competent to stand trial. And there are different burdens of proof, etc., that will come into place. Next slide. So when we're looking at who may request a competency hearing, who can raise these issues in a criminal case. So, I want to kind of draw your attention to the fact that we've got a criminal charge that has been filed in your criminal court, and now we have some concerns about this defendant and whether or not they have mental health issues that will impact that case moving forward. And so the question then becomes who can bring forth these questions to the court and get the competency of this individual assessed. And the defendant may, upon their own, raise these issues to the court. Often defendant's legal counsel will bring forth these issues. And in some instances, it may be the prosecutor or attorney for the tribe that brings forth these issues. And part of the reason that a prosecutor, you might question why would they bring forth these issues? And the reason being is that there are some standards that are going to apply where if we move forward with an adjudication, knowing that an individual that there's a potential competency issue here and we do not address it, it can actually cause us problems after the fact. So it's in everybody's best interest to move forward with the criminal adjudication in a manner that's fair, in a manner that is cognizant of the rights of individuals under the Indian Civil Rights Act or under the laws of the tribe. Next slide. So when we're looking at criminal cases, really the competency of an individual can come into question at any point during the criminal adjudication. There's no, one point in the criminal adjudication where you have to raise the issue or you lose the right to do so. It can come forth at any point. And really, the reason for that is we may not have reason to know of competency or mental health concerns early on, that we may only learn that after interacting with an individual over time, or the individual's mental health may change from the point that we first bring them before the court to the point that we come to stand trial, for example. There could be changes in their mental health status during that time. So you can raise these issues typically at any point, but you should always consult your local rules to make sure that that is allowable in your tribal jurisdiction. And really, when we're raising the issues, we're focusing on the defendant's ability to understand the criminal proceedings and their ability to properly assist with the defense. And this comes from what is called the Dusky Standard. And the Dusky Standard comes from a 1960 U.S. Supreme Court case called Dusky versus United States. And a couple of things about that case that came about, and one thing I think is important to note, the court did indicate in that case that doing a brief mental health exam is not enough. in order to meet the standard of a proper evaluation. So you're going to want to be looking, if you're going to be doing evaluations and competency proceedings, a 20-minute meeting with a counselor is probably not sufficient. There's going to need to be a more thorough evaluation done. And secondly, there's a two-pronged standard really that the court's going to be looking at when determining whether someone is competent for criminal purposes. And that is the defendant must be able to have a rational understanding of the charges and the legal process. And the defendant must be able to rationally communicate with their attorney or legal representative. So those are kind of the standards that emerged out of that 1960 Dusky versus United States case. And I realize that some of the U.S. Supreme Court cases will have more or less impact on tribal adjudications. But I think whenever we're looking at, a general standard, it is always in our best interest to understand that if there's been a case that has interpreted the standard under federal law and under the United States Constitution and the rights under the United States Constitution, it's good for us to know that, even though the rights that we might be affording in tribal courts come under the Indian Civil Rights Act. Oftentimes, we're going to meet a same or similar standard. So it's good to be aware of that. Next slide, please. I wanted to bring up to your attention to a couple of federal laws. Now, these are going to apply in federal criminal cases. They do not automatically apply to tribal criminal adjudications, clearly, but I think it's good to know what the federal standards are in federal courts, especially if you're looking at developing your tribal laws or your tribal codes. It's good to have awareness of what's happening at a federal or state level, not because you necessarily want to replicate in entirety, but at least having some measure of consistency can certainly be helpful as we're building our criminal court capacities. So 18 USC 4241 sets forth that the conviction of a defendant while they are mentally incompetent violates due process. Now, if you'll recall back when I said that in some instances we may have a prosecutor who raises the competency issue to the court, this is an example of why. Because if they don't raise the issue, and they should have, and they go through an entire trial process only to later determine that an individual was in fact incompetent, we could have a due process violation, which could unravel the whole case. And so we don't want to have that type of waste happening in our courts. And also, we want to make sure that we're affording people the due process that they are entitled to under the law. Under federal law, when it is raised that a person that is a defendant in a case may be suffering from a mental disease or defect that is rendering them incompetent to the extent that they're unable to understand the criminal process, the nature and consequences of the proceedings that they are involved in, or to effectively communicate with their defense counsel. At that point, the court can order the defendant, they can have a hearing on the matter to determine criminal competency. Next slide, please. And 18 USC 4247 indicates what will happen at the hearing itself. So at the hearing itself, the defendant is going to be entitled to be represented by legal counsel. And a big part of that, even if it's a civil proceeding, a big reason that you may want to afford that right to individuals is because we have this intersection of the criminal court hearing and the civil court hearing. So affording that right to counsel is a good idea, certainly, particularly when you're looking at developing your codes. The individual will also be given the opportunity to testify, present evidence, subpoena witnesses, cross-examine or confront witnesses against them. And then also in determining whether the defendant is competent to stand trial, the court then is going to determine whether or not that individual has sufficient and present ability to consult with their lawyer with a reasonable degree of rational understanding, and whether they have a rational as well as factual understanding of the proceedings against them. And again, this is coming from that Dusky versus United States case from 1960, which is referenced here. Next slide, please. Also at 18 USC 4247, I wanted to point out to you all that what is included in the evaluation. And if you'll remember, I said that that Dusky case said that this kind of brief 20-minute type of interaction is like not likely to suffice, right? So what we're looking for is a psychiatric or psychological report that would be prepared by a psychiatrist or a psychologist who's gone through a formal evaluation or examination with the defendant, and they will then provide that report back to the court. And a couple of things, there's some things that need to be included, including the person's history and present symptoms. And then 18 USC 4247 goes on to detail additional requirements for those reports. So if you're fashioning a tribal law to address competency in your jurisdiction, it might be a good idea to take a look at what is required of the psychiatric or psychological examination on the federal side, and to consider whether you want something same or similar under tribal law to ensure that the information that is being communicated from the service provider, your psychiatrist or your psychologist, back to the judge is thorough and gives the judge sufficient information to make a determination upon. Next slide, please. So there are several tribes. I've mentioned, if you're developing your tribal competency provisions, there are some tribes that have competency provisions in their codes. This is not an exhaustive list, nor are we saying that this is that these codes are, necessarily best practices, but they are certainly some examples that you can look to. So I think Judge Jones had already mentioned Turtle Mountain Band of Chippewa and their civil commitment. They also have some provisions relevant to competency. And in theirs, they have created a board of competency reviews, which is kind of an interesting approach. We also have the Confederated Salish and Kootenai tribes of Flathead. And they make the court in under their law makes a competency inquiry prior to accepting any plea. Now, remember, I had mentioned earlier that competency is something that you can typically or generally raise at any point in a criminal proceeding. And so what the Salish and Kootenai tribes have done is they've made sure that the judge is going to bring that to the attention of the litigants before they move too far into the criminal process. Now, that doesn't necessarily mean that it can't be brought up later, but having that preliminary inquiry is a really good idea and can save a lot of time in the criminal adjudication process. Fort McDowell, also, they have provisions that include some factors that the court can look at to determine if a competency hearing is necessary. So if that's something you're interested in, that's a good example. And then Gila River has provisions noting that competency can be adjudicated at any time prior to sentencing or after commencement of probation or before completion of the sentence. So again, when you can raise competency questions is another provision, I guess, if you want an example. Gila River has one. And then also, before we move on, just real quickly to the next slide, I know that BJ had also mentioned the burden of proof, kind of in the civil commitment with the clear and convincing being maybe a best practice for a burden of proof. In the criminal competency realm, the general burden of proof that we see pretty consistently is a preponderance of the evidence, which is a little bit lower standard of proof than that clear and convincing. And so if you're asking yourself why, think back to the purpose of a civil commitment versus the purpose of a criminal competency. The purpose of a civil commitment being to compel someone who is unwilling or, doesn't want to volunteer to undergo treatment to do so, but there's no underlying criminal charge. Whereas in a criminal competency proceeding, we have that originating criminal charge that first brings us into the court. So that's a big difference. Next slide, please. There are also, we also wanted to kind of point out to you, particularly those of you that might be working on enhancing or developing your tribal laws, that there are state laws out there as well. And a lot of the state laws have been pretty consistent when it comes to determining competency, when you can raise competency questions, what the hearings will involve, and the evaluations, etc. Many of the state laws do leave the actual decision to the judge after the psychiatric evaluation has been completed and returned to the court. It will typically be up to the judge to review that, and then based on their review of that information, determine whether or not the individual is competent to stand trial. And I do know that there are a couple of resources that were that Chantal Cloud actually found through SAMHSA. And I don't know if those have been included in the chat or if they will be circulated to those who would like them after. But I do want to point one thing out. A lot of the tribes that are doing commitments and competency have reported that they're experiencing delays in accessing psychiatric services. They're experiencing delays in receiving reports. In some instances, they're getting just pure noncompliance, or they're having difficulty locating service providers. They're also having, providers on the back ends of competency proceedings. And these couple of documents that Ms. Cloud came up with that can be shared with you are, I think, important for us to look at, because they provide us with some information about what's happening at the state level with competencies, the fact that many states are backlogged when it comes to competencies, and they too are experiencing many of these delays. And so this intersection between the courts and the service providers, the psychologists and the psychiatrists, is something that we all really need to work on as justice system professionals and as service professionals, to try to bridge those gaps, to try to come up with ways that we can reduce some of the delays that we're experiencing, to make sure that these adjudications can go forward in a timely manner. Next slide, please. When we're looking at another thing with civil liberties, and I know BJ touched on a little bit on this in this civil commitment section, but when we're looking at competency proceedings, I wanted to just kind of bring up that federally, people who are subject to criminal competency hearings do have the right to a separate hearing to determine if they are competent or not to stand trial. And that comes from the U.S. Supreme Court case of Drope versus Missouri. And then also, individuals who are facing criminal competency hearings have that right to counsel, to testify, present evidence, subpoena witnesses, etc. And I kind of had mentioned that. And this might extend to tribal courts through this Indian Civil Rights Act, since we have individuals who have due process rights under the Indian Civil Rights Act. So just wanted to point that out, to be aware of that. And then before we move on to kind of this some last discussion on some of the issues, obstacles, and challenges with commitments and competency, I just wanted to also point out that if an individual is declared to be incompetent after the evaluation and review by the court, typically what will happen is that the criminal case will be suspended, and the court will often order the defendant in that civil competency proceeding, will order that defendant to be committed and placed in an inpatient location for purposes of restorative treatment. And so this doesn't mean that they necessarily get off the hook on any of the criminal charges, but they may be placed in a facility until such time as they are determined able to stand trial, or until the court orders them to be released. And so there might be some provisions you want to address through that in your codes as well. And again, as Judge Jones mentioned, having timeframes in there for periodic reviews is really important, so that we don't forget that somebody is sitting in an inpatient facility for 15 or 16 years. That's not something that we want to do, right? And so having some of those time provisions built into your codes to ensure that there are review hearings can help to prevent that from happening. Next slide, please. We're going to really kind of quickly move through some of the obstacles and challenges here that we're seeing, and then we want to leave a few minutes for question and answer. So, kind of first getting into, some of the obstacles and challenges we're seeing is that some tribes may not have code provisions at all to either address competency evals, hearings, or civil commitments. Some tribes do have codes, but they may not be thorough enough to meet the needs or demands of the court and or the individuals presenting before the court. And then some requirements of tribal codes may vary so much from state and federal requirements that it can cause some challenges, particularly when we are working with service providers who are off reservation. So having some familiarity with the state and federal requirements and then giving consideration to whether or not you might want to make some amendments to your code is a good idea. Next slide, please. As Judge Jones also mentioned, enforcement of court orders is something that I think tribal court orders, particularly in off-reservation facilities, is something that we sometimes have challenges with. He did point out that I know there's like Michigan, North Dakota, and several others have some specific rules under state law that have helped to facilitate the enforcement of court orders. But just be aware of that. And as you're developing your tribal codes and as your courts are issuing orders and interfacing with state providers, take a look at your state law and see if there's a mechanism in place, a state rule, for example, that will help to facilitate the enforcement of your court orders. Next slide. Oh, and then also competency evaluations. Another thing is returns of findings from the evaluations or accessing off-reservation service providers is proving to be a challenge for some. There are a few things that tribes can do about this. One of the tribes that I worked with, they actually ended up doing a consulting agreement with a psychiatrist. The tribe did, and that psychiatrist handled all the referrals for civil commitment evaluations and competency evaluations out of the tribal court. So that's one way to address it. In other areas, you may have some BIA clinicians that are able to conduct the evaluations within the reservation, but building that local capacity is helpful. The other option is, of course, to sit down with some of your partners at the state level and to work through some of the issues and express to them with some measure of clarity how the timeliness impacts in a negative way the adjudication of cases and the safety of the community and the individual. Next slide, please. Costs are another thing. Whenever we're looking at getting mental health services, whether it's civil commitment, whether it's competency, questions arise, who's going to pay for these services? Is the individual going to be responsible? Should private insurance be responsible? Medicaid, Indian Health Services? Is there Department of Justice funding that might be accessible? Tribal funding, SAMHSA funding? There's no necessarily one answer to this, but we want to point this out so that as planners, justice system planners, and code developers, you're aware that, cost, who bears the brunt of the cost is going to be something to consider. Next slide, please. And then professional services, who's available to complete these evaluations. And as I mentioned, there's a number of options that you might consider. There might be off-reservation service providers. I know BJ also mentioned like state facilities, keeping in mind that our tribal members are also citizens of the states in which they are located. There are also private folks that we might be able to engage through consulting agreements to perform these services. Costs are always a factor with that. And then it's not just about getting the evaluation completed and the report back to the court, but are those professionals able and willing to come into the tribal court and testify if necessary? That's something else to give some consideration to. And then finally, I think this is a big one. I've seen this time and again in my 20 plus years working within tribal courts as a prosecutor and as a tribal attorney. The travel and transportation issues are always creeping in. So, for example, particularly when we have off-reservation service providers who are conducting evaluations, or if we're relying on off-reservation service providers for our inpatient treatment services, travel and transport, getting those individuals, those defendants, or the litigant, the respondent in a civil commitment, how do we get them from the courthouse or from our holding facilities to the treatment facility? And in some instances, I know there have been times where, we've relied upon law enforcement to do those transportations because of some of the safety issues that are involved with individuals, particularly with mental health or those going through withdrawal. We've had other instances where maybe we've got medical providers such as EMTs providing those travel and transportation. I know many of those agencies will cite to liability concerns. So there are issues here that we have to work through as we're implementing, not only as we're passing tribal codes, but to ensure that we can effectively implement those codes. And I think that's it for the competency piece. And we wanted to leave a few minutes at least for people to be able to ask questions. And so, Catherine, I'm going to turn it back to you.
I'm going to go ahead and hop on. Michelle, it does look like there are a couple of questions in the chat box. So the first one is, any examples of tribal competency restoration on the criminal side of things?
I do not have a tribal restoration, like a specific competency restoration. I do know that there are tribes that have some of their own inpatient facilities, like mental health facilities. But with how much they're engaging with their criminal courts is something that we would have to look into. So nothing specific off the top of my head.
Okay, thanks. And then the second one is, what are the differences in juvenile competency?
So juvenile competency is it's actually something that's come about, and there's a lot of questions around it recently. For many, many years, our juvenile courts date way, way back. And so with that Dusky standard, the Dusky standard has typically been applied also in many juvenile proceedings, particularly in federal and state courts, and also arguably would have applicability within juvenile courts. But there have been several articles that have been written recently as we learn more about childhood development, brain development, and that raises more questions about competency. And so I think if you look at that general standard of competency from Dusky, and maybe even require additional inquiry because you're dealing with juvenile and taking into account childhood development, you would be on the right track for that. And there are some like I said, some legal articles that have been written, particularly about juveniles. And so we can certainly look further into that if there are people that are wanting some of those resources.
Thank you. Catherine, did you have anything additional to add to that, or Judge Jones?
Nothing else to add on my end, Chantel. Thank you.
Okay, so we did have a third question come up, and it's, does court-ordered treatment for restoration of competency involve the same rights as civil commitment?
I'm sorry, can you repeat that, Chantel?
Does court-ordered treatment for restoration of competency involve the same rights as civil commitment?
I would say, I'm not sure unless we look at exactly the specific right. There are due process rights, yes. So in that regard, there are the same rights. The rights of due process will attach in both proceedings. And that comes from some of the cases that we referenced here. But when we're looking at restoration, we're not looking for like the end result. In civil commitment, we might be looking for something a little bit different than in a competency. In competency, we're looking at restoration to the point that the individual is able to understand the court proceedings and is able to effectively communicate with counsel. In a civil commitment, we're looking more at, is the individual going to be, are they in a place where they're no longer a threat to themselves or others, right? So we're looking at different outcomes potentially in both of those cases, but due process rights do attach in both.
Yeah, and the competency placement, the issue of whether you're a danger to yourself or not is not the issue. It's you need to get help to become competent so you can be tried. So yeah, I agree with Michelle on that.
Okay, I'm gonna see here. It looks like we have one more question come up, and the question is, when a person is civilly committed for mental health issues, what rights does family have, if any, after the initial threat is no longer present?
Yeah, and that would depend if the family members were the petitioning parties, they have all the right to the evaluations, all the right to participate in the hearings. It gets delicate though when the tribe is the petitioning party and the respondent, the person subject to commitment, doesn't want the family involved. In that, most of these proceedings are confidential. So as a judge, I would say that that person has the right to say, I don't want my family in here. But if the family was part of the petitioners under the code who submitted the application to the tribe to commit, I think they're parties and they have every right to be there. But it depends on what your code reads. I mean, these are confidential cases, so a person can say, I don't want my family involved. I don't want them to know what the evaluation is. But you know, you and your code can address that situation because having family involved is important to healing people from substance misuse and mental illness.
Great, thank you. If anybody else has any questions following the webinar, you could always reach out to us with those questions and we can get those responses to you. But if there aren't any questions at this time, we'll move along. And so I would like to thank everybody for attending today's webinar, addressing mental health and substance misuse issues through civil commitment and criminal competency proceedings in tribal courts. And I'd like to thank our partners, Michelle and BJ at TJI, for joining us today. Again, as mentioned earlier, the webinar recording will be posted on walkingoncommonground.org and will be sent out to our mailing list as well. We do have the QR code up on the screen. If you would kindly fill out the webinar evaluation before you leave. It's also been dropped in the chat as well, I believe. So just to note, this webinar is part of a series of monthly webinars to support the development and enhancement of tribal courts, tribal judicial systems, and intergovernmental collaborations. These webinars are brought to you by the Tribal Law and Policy Institute, the National American Indian Court Judges Association, NIJA, and the Tribal Judicial Institute, UND School of Law, TJI. The next upcoming webinar will be on Wednesday, January 22nd, and the save the date will be sent out with more information soon. And again, as a reminder, the link for the evaluation is in the chat box, as well as using the QR code. And your feedback is greatly appreciated. So we will stay online for a few minutes to allow you time to fill those out. Thank you.